Hey guys, welcome back to week 5 of the business law course y'all are taking. This week we're going to be going over chapter 9, which is capacity and legality of the third and fourth element to make a contract. Again, this PowerPoint is posted already on Blackboard, so you can check it out and then review it or follow along with this video. And then I know I've said it several times before, but if you go back and maybe read chapter 9, or at least have it with you and read through it with the PowerPoints, I think it's going to make the presentation and the subject matter, it's going to make a lot more sense when you've already kind of read the chapter, reviewed it, and then follow along with us as well as the PowerPoints. Now again, chapter 9 is going to go over capacity and legality, which is the third and fourth element of a valid contract. You would remember that last week's or chapter of week 4 was chapter 8, which was the elements, the first and second element, which the first one was the agreement. In the agreement, there needs to be an offer and acceptance. And then the second one was consideration. So we'll go over the third and fourth element, but we'll also touch a little bit, just a quick review on last week's, week 4, the offer and acceptance and the consideration. We'll touch on that just on two presentations, but let's jump on and let's go on the next slide to talk about these. We're jumping onto here to slide number 2, which is the chapter learning objectives. First one, we're going to review the element of an agreement, which we discussed last week, which the agreement is going to encompass an offer and acceptance. We're going to review the element of consideration. Consideration, as you know, was the second element for a valid contract. We discussed that last week, but we'll briefly touch on it in this presentation as well. We're going to articulate the legal requirement of capacity and identify the main categories of persons who do not have the full legal capacity to incur contractual obligations or duties. We're going to distinguish between the bright line rules and the flexible standards. And then lastly, we're going to articulate the concept of legality, that is the lawful object. Okay, well, let's go on to the next slides and let's review these concepts here. Now we're jumping on here to slide number 3. If you remember, if you're thinking this slide looks familiar, this slide, I pulled it from last week's presentation. Just wanted to make sure and touch on these things again, because I think these are very important for contracts. So the first one is the elements of a valid contract. As we know, there are 4 elements to make a valid contract. The first one is, as you see there in the slide, is an agreement. The parties to a contract must indicate through their words or behavior that they are willingly agree to enter into a contract. Now, there has to be, in order to be an agreement or an agreement, there must be an offer and an acceptance. And that's usually how parties will demonstrate the first element of an agreement. The second element of a contract is there must be consideration. Now, this element requires both sides to obtain something of value, a legal benefit, and give up something of value, or we can call it a legal detriment, or it must be, for the lack of better terms, some sort of burden. So they must get something in value and give something, or have a burden. Both parties must do that to meet the second element of consideration, which we discussed last week as well. Now, the 2 new elements that we'll discuss in this presentation is going to be contractual capacity. Both parties to the contract must have legal standing to be able to enter into contracts. So basically, legal standing is they have to have the capacity. They must be able to understand what they're doing to be able to have a valid contract. Now, the fourth element is a lawful object. A contract must satisfy a legal purpose to be enforceable. It has to be for something legal. We cannot enforce, or the courts cannot enforce a contract that the intent or the purpose of it was for something illegal to be done. Therefore, that needs to be captured as well. Now, the next slides, I think there are 3 or 4 slides. We're going to review the slides that we discussed last week. We discussed the agreement and the consideration. Those are the first two elements we discussed last week. So let's touch on those. And then after those slides, then we'll jump into capacity and legality of a contract. Okay, so let's go on to the next slide. Now here on slide number 4, which we discussed last week, but I thought it's a valid point to bring it up again. We're going to discuss the 4 different statuses that a contract can be on. First one, a contract, of course, can be a valid contract. This when a contract required all the elements or met all the elements. So this is when it would be a valid contract. All four elements have been accomplished. Now the second one is a void contract. When an agreement lacks one of those four elements or has not been formed in conformance with the law, then from the onset or from the beginning, then the contract is considered a void contract. Now the third one is voidable. Now this is differentiated from void. This is voidable. A contract is voidable when the law gives one or more parties the right to cancel an otherwise valid contract under the circumstances. So it's a valid contract, however, the law gives one party the right to cancel it at any time. That is when it is a voidable. It is a void contract, but may become later voidable at a later date. Now the fourth one is unenforceable. Although a contract may have met all the required elements and be considered valid, it may still be unenforceable because one party asserts a legal defense for not performing his or her duties under the contract. So there's four statuses to a contract. We know it's valid, void, voidable, or unenforceable. Now I know these, you may think, oh, I already know this, because you should, because this was from last week's presentation. So if you do know it, good. But I just wanted to make sure I included this because this is a good review from last week, because we're a lot of this time that we spent together for business law is regarding contracts. So I just want to make sure we drill that down so it's ingrained in you guys and you know this. Let's jump on to the next slide. Now slide number 5. This is one of the elements that we discussed last week. Again, this slide was from last week, but I put it in here just a quick review. As we know, 4 elements to a contract. One of the element is the agreement. Now, as we know, in the agreement is 2 parts. There must be an offer and there must be an acceptance. Now, as you see here, an agreement is reached by the offer and acceptance. Now, this is often referred to as the meeting of the minds. When the offer and acceptance comes together, that's when the meeting of the minds have met. Now, an offer is a promise or a commitment to do or to refrain from doing something or a specific activity. Now, objective intent. A reasonable person would conclude that the offer or the person making the offer is serious in their intent to contract. Now, a judge or a court may have this objective intent that if someone offers something so ridiculous that in the court's eyes or in a reasonable person's eyes, they would say, that wasn't a serious offer. That was a joke. That was just, to get attention, or that wasn't necessarily a real offer. It's always looked at from an objective intent. If, for instance, someone says, I will offer you $20,000 for you to give me a flower that you have there in your garden or something like that. Then if you give them the flower, then you can say, I want $20,000 or $1,000 or whatever. Then you can say, I was just joking. I wasn't serious offering you $20,000 for a flower. And then maybe if you sue that person or you give them a lawsuit and you take them to court, then a judge can look at it and say, with an objective intent, and say that a reasonable person who was offered that would know that that was not a reasonable offer. That was not a real offer because it's just not real. A reasonable person wouldn't conclude that. So whenever a person makes the offer, it must be at least somewhat reasonable for an objective jury or an objective person to say, that was a real offer, therefore that element was established. Okay, well, let's go to the next slide. Now, slide number 6 here. Again, sticking with the first element of a contract, the first element is there must be acceptance. Acceptance has two parts to it. There has to be an offer and there has to be an acceptance. The acceptance is the offeree's expression of an agreement to the terms of the offer. So in order to establish that there has been an agreement by 2 parties, we have to establish there was an offer and there was an acceptance. Now, the acceptance, as we know, can be in several forms. It can be written, it can be expressed, it can be perhaps by doing something, by the person who wants the acceptance, by him starting to do the job or something like that. But an acceptance is not necessarily one way to accept it. There are several ways to accept it. For instance, the easiest way, as you know, is signing a contract. If someone presents you an offer and has a written offer, I want to sell you this pen for $1, then if they wrote that in an email, I think that can be pretty clear, establish that an offer has been met. If you respond back with the email, I accept your offer, or something like that, that can easily show there was an offer and an acceptance. Sometimes if it's not as clearly that clear, if someone says, hey, I want you to, I wrote you an email and say, hey, if you want to mow my lawn today, anytime today, I'll give you $20 to do it. Now, if necessarily that lawnmower guy starts mowing the lawn, but necessarily doesn't respond back by saying, I accept it, instead of he just has an affirmative response by just physically going out there and starting to mow, that may already meet the element of acceptance because he started to do it. There was an offer, and someone can reasonably infer or reasonably say that, when he started doing it, that was obviously an acceptance from the offer. So that's another way to accept the offer. It necessarily doesn't have to be written, but it can be in the form of taking a step forward or somehow doing something that shows that you accepted the offer. Now, the offeror, they always have the power to terminate the contract, modify its terms, or prescribe the method, meaning of acceptance. So they can tell you, in order to accept this offer, you need to accept it by midnight tonight, and it must be in a response to this email. Then that's the way the offeror has the power to control after or over the offer. So there are several ways that he can do that. And any offer that he makes, it is his offer, his or her offer, and the power to revoke, the power to change, or the power to tell the person, this is the way you must accept my offer. That all lies with the offeror. Well, let's jump on the next slide. Now onto slide number 7, consideration. Now we just went over the first element, which is the agreement must be met. An agreement is based on an offer and an acceptance. That's the first element, agreement. Second element is consideration. We discussed this. This is the same slide from last week's video. However, I just thought it'd be great to include it here because it's very important. Second element is consideration must be met. Now, consideration is the mutual exchange of benefits and detriments, the benefits and burdens. As we met both, to make consideration, one party must give something of value, basically give up a burden, and get something of value. Each party must do that in order to meet the consideration element. It has to be a bargain for exchange. It has to be fair. A legal benefit is receiving something of value from the other party. Because if you're not receiving anything of value, then why would you even enter into a bargain or a negotiation if you have no intent to get something of value? Anytime someone enters into a negotiation, it's always for something of value. A legal detriment is giving up something of value to the other party. It may be it may be money, it may be time, it may be service, it can be property. That is a legal detriment or a burden. Now, a forbearance is a promise not to do something that you are legally entitled to do. So in that case, you are giving up your right to do something. So in meeting the legal detriment, you may be gaining something of value. And if you're giving up a right that you have a right to do something, then that's the burden you're taking. That is your legal detriment that you're gaining. So if you're doing that, you would meet the element of consideration. Now, the amount and the type of consideration. Consideration exchange does not need to be of equal value, and courts will not look at the amount or type of consideration for bargaining for these type of parties. Now, one example can be if parties come into the negotiation and perhaps maybe one is a better negotiator, one was better prepared, knew the facts, and just outdid the other person, got the better end of the deal, right? Then they cannot argue. The person who got the worst end of the deal cannot later argue and say consideration wasn't met because I didn't get that much value. I gave up more than I got. And the other person got a lot more but didn't really have a detriment, doesn't really have a lot of burden. Therefore, the scales are tipped in a manner where one can argue there was no consideration. Now, as the next one, nominal consideration. Nominal considerations can be the basis for a valid contract. Now, the amount and the type and nominal consideration, that still hits the element of consideration. So you cannot go to the judge and say, you know what, I'm a bad deal maker. I got taken advantage of. I paid a lot and I got very little. Then the judge doesn't look at the amounts. He or she just wants to know that there was some consideration. You did get some value and you gave up some burden. the other person did get something of value, and the other person did give up something. Again, if it was really lopsided and it was a good deal for one person and a bad deal for the other person, that's not the judge's right or obligation to say, you know what, consideration wasn't met because it was so lopsided, therefore it wasn't a valid contract. No, nominal consideration, small consideration, it's still consideration. So the element would still be met if it was very lopsided. Okay, let's go to the next contract. The next slide. Now I'm getting on here to slide number 8, capacity. Again, capacity is one of the 4 elements. If we're going in our order, it would be the 3rd element. Again, we discussed an agreement is an offer and acceptance. Second, consideration. It must be bargained for. There must be both parties must get a benefit and get a burden. Now, the 3rd element we're going into is that we haven't discussed. It's new here. Is capacity. Now, capacity is a legal doctrine used by courts to protect parties who may lack the ability to understand the terms of the agreement. They must be capable of understanding the agreement or the contract and capable of contracting. Now, minors, mental incompetence, and intoxicated persons may lack the full legal capacity to make legal binding contracts. Now, if we know if a minor, if I sign a contract with a minor, hey, minor, I want you to sign a contract that I'll pay you $20 to mow my lawn for every week for the next 8 weeks. So I'll give you $20 a week and you promise to show up. If I sign it as the homeowner and then the one who's going to cut the lawn is a 10-year-old boy who signs it, then that boy is a minor. He won't be held to the standard. I can't sue him and say, you know what, there was an offer, I made the offer, and he signed the contract, the minor, so we met the element of an agreement. Second was consideration. Yeah, I was going to get something of value. I was going to get my lawn mowed, and I was going to get a burden. I was going to pay $20. Same thing for the 10-year-old boy. He was going to get something of value. He was going to get $10, and he was going to get a burden, which would be his time to mow my lawn. However, the judge would say, yes, you met the first element of the agreement because offer and acceptance. You met the second element of consideration. However, clearly, well, I guess not clearly to everybody, but you did not meet the 3rd element of capacity. It was a minor, and not speaking for, I don't know, there's a lot of smart 10-year-old boys out there, but the judge will assume that the minor, since it was a minor, he didn't understand what he was signing. Therefore, the 3rd element of capacity was not met. Now, it's good to know that contracts made by these persons, the minors, mental incompetence, or intoxicated people, their contract signed that is a voidable contract. Now, it's not a void contract. A void contract when it's an illegal contract. You know, it's saying, you know, I want you to do something. I'll pay you X amount of dollars if you smuggle in Cuban cigars for me. That's an illegal contract, so that's a void contract. This is not a void contract. This is a voidable contract. Now, they may be later affirmed or accepted or rejected by the person who lacked capacity. So the minor what has the upper hand by saying this contract is voidable only by him. If he still wants to mow my lawn for the next 10 weeks or however weeks for $20 a week, he can still come back and enforce it on me because I had mental capacity. I signed the contract, but he has the opportunity and the choice to void it and make the contract a voidable because he can enforce the 3rd element of capacity. He didn't have capacity, therefore he's able to void the contract, get out of it, or if he chooses, he's able to enforce it on me because I did have capacity. Now just make sure that it being if I contract with a minor, someone who did not have capacity, I don't have the right to cancel or the contract. The contract is not voidable for me. It's a valid contract for me. However, it's voidable for the minor, and he can choose to void it or to pursue it or to move forward with it. So that's just a difference for someone who has capacity. They may have that extra upper hand. So they basically have a contract for just the other person who made it, and they can sit on it and say, do I want to do this or not? Although it's a valid contract, they have all the decision. Everything lies with them. Let's go to the next slide. Now here on slide number 9, we're going to continue talking about those individuals who do not have capacity, specifically minors. Now, contracts of minors, those are persons usually under the age of 18. Now, if a minor, someone under the age of 18 signs a contract, then that contract is voidable, as we mentioned, at the option of the minor. Now, we're going to go three things I did want to know. There's something called ratification. Now, ratification is any act that indicates the minor intends to be bound by his promise and may be expressed orally, in writing, or can be implied. As we mentioned earlier, a contract is voidable. If the minor wants to continue with the contract, although he has a defense of being a minor, he doesn't have capacity. If he says, you know what, that's okay, I still want to move forward with the contract, I want to ratify the contract, then he can do so. He or she can do so by doing expressly, which is writing or orally, but continue with the contract, and he can be bound by the contract. However, if he ratifies the contract and moves forward, there's also the disaffirmance. Now, when a contract with a minor has been performed, partially performed, the minor must invoke an action to avoid obligation under the contract. The result would have to be the contract can be rescinded, and each party must return any consideration received from the other party. Now, I just read that definition on the PowerPoint, but some of you may be thinking, what the heck does that mean? Okay, so if a minor signs a contract, say for instance, I'll sign a contract that if I promise that Professor Ramirez, if you give me your blue pen, I'll give you $1. I said, okay, so basically I sold him the pen for $1. We had a contract, I'm going to sell it to you for $1. Once you give me the $1, I'll give you the pen. So if once I signed that contract that he was supposed to give me $1 for his pen. Now again, that's a voidable contract. I can't go and tell him, you signed the contract, give me $1, here's the pen, you signed it. Now the minor says, you know what, let me think about it, professor, because I'm under 18, I'm a minor, so I know I told you I want to give you $1 for your pen, but let me go shop around, let me go see if there's cheaper pens. I cannot sue him on that because it's a voidable contract only for his benefit. So let's say that minor waits and comes back a couple of days later and says, that was a good deal, your pen for $1, I like that deal, here's $1, and I gave him the pen. So that's just, he met the ratification element. He did some sort of expression, orally or in writing, or that it can be implied by me making the contract and then him giving me $1. It can be implied that he wants to be bound by that contract. So therefore, I give him the pen. Let's say that's the contract. But say the next day he comes back and he says, you know what? It was a voidable contract, although I did. There was ratification because I did give you the $1 and you did give me the pen, but now I want disaffirmance. I want to void this contract. So as long as he gives me the $1, the pen back, the minor gives me the adult the pen back, then I have to give him his $1 back. Then he can still void the contract if I still have the $1 and he still has the pen, because I took the main thing to know here is an individual is the one taking all the risk when they contract with a minor, because we're trying to deter that. We're trying to make people not contract with minors, so all the power lies with the minor. So that's why it deters people from making contract with minors, which it doesn't meet the element, so it's good not to do it. But if the minor still moves forward and makes the element of ratification and gives me the $1, I give him the pen, someone who sells pens thinks, oh, okay, great, yeah, I'm going to sell these pens to all these minors, but they still have the power with them. They may come back and say, here's your pen back, just give me my $1 back, and I still have to give them the $1 back and take the pen back as well. So that's disaffirmance. They can still cancel the contract even though the contract has almost been performed already. They can still come back and cancel it later and want their money back. Now, just a quick note that I put this on necessities. Now, however, minors may be liable for purchases of food, medical, or other necessities needed to live. Now, there's a minor who contracts for health care. If they go into the hospital and they need for an emergency or things like that, they might sign a contract, receive emergency help from physicians or nurses or medical professionals. But at that point, they may still be bound by that contract, even though they are minors. They will not have the right to just say, oh, that's a voidable contract, thanks for everything you did. However, I'm not going to pay my medical bills or or anything that I did for food or water or anything like that. Now that contract may still be enforced on the minor, but I just wanted to make sure, I wanted to point that out, the necessities clause. Let's go on to the next slide. Now here on slide number 10, it's going to cover the mental competency. That's going to be one defense from for not having standing, the capacity to enter into a valid contract. Now mental incompetence have, of course, as you would know, they have a limited capacity to contract. Now mental incompetence include those with mental disorders and perhaps maybe dementia, as well as those who are temporarily incompetent. Not perhaps maybe it's permanent, but something for a temporary, for that time that they signed the contract, they were mentally incompetent, they were unable to sign the contract. So these, if you're thinking, at that moment, you can think of people who are highly intoxicated, perhaps severely depressed, or under severe traumatic pressure. At those times, those individuals do not meet the capacity to sign or enter into a contract. So let's discuss a little bit more about this and a good example. Let's go on to the next slide. Now this is slide number 11, still building off the last slide, the mental competency. We're going to discuss the lucid period rule. Now the lucid period rule, the main thing is, the question is whether the person, the individual, is lucid at the time of contracting. A person is not lucid, meaning they don't have the capacity to sign, if they are either, number one, unable to understand the nature and the consequences of the contract. So that's one element. They are not lucid if they are unable to understand the nature and the consequences of the contract. Or, number two, they are unable to act in a reasonable manner in relation to the transaction, and the other party has reason to know of that condition. So second, they are unable to act in a reasonable manner in relation to the transaction, and the other party has reason to know of the individual's condition. Now I want to go over an example here in your book that's on page 217, just to illustrate a good point. Now, for example, at the top paragraph on page 217, Oliver has Alzheimer's disease and enters into a contract with Wendell to sell him 100 widgets for $1 each, for $1, I'm sure, per widget. And let's assume that's fair market value, that's normal. He's not taking advantage, he's not getting a deal or anything like that, but that's just a fair market value. Now, Oliver, the individual, the seller, the one with Alzheimer's disease, may avoid the contract even though the contract terms were fair, and Wendell had no idea of Oliver's Alzheimer's disease. So let's say if it was a fair contract in number wise, and one party, Wendell, went in there not knowing that the other party, Oliver, had Alzheimer's disease. Now this is still, even though Wendell, there's still a voidable contract by Oliver, the person who had Alzheimer's, because Oliver has met the unable to understand the nature and the consequences of the contract. Now, this defense is true. It's generally, say for instance, for older individuals or the elderly individuals, they can say, you know what, they were unable to understand the nature and the consequences of the contract. They had Alzheimer's, or perhaps maybe they have dementia or things of that nature. The other person cannot say or fall back and defend themselves by saying, well, I had no idea that they had Alzheimer's or dementia or things like that. And just because they're saying I had no idea, therefore I didn't take advantage because I had no idea. But this is where the contract is voidable. The contract is voidable by the individual who did not have capacity to sign. That individual, in this example, Oliver, has the option to make the contract void. It's a voidable contract at Oliver's choice, even though the other person, Wendell, had no idea of Oliver's condition. I just thought this was a good example to illustrate, to show that even if one party's innocent, doesn't know the other party's situation or circumstances, they can still fall under the trap that make the contract voidable. Okay, let's go on the next slide and discuss the next stuff. Now jumping on to slide number 12, still going on those who are unable to contract or have capacity to the contracts, we're going to talk about intoxicated persons. Now, this may be intoxication through drugs or alcohol, but both of those will definitely affect the ability for someone to have capacity to meet that third element. Now, just to note, the courts use an objective standard to determine if a reasonable person would have believed the intoxicated person had sufficient capacity to enter into the contract. Now, again, I want to read an example here in your book that illustrates this or gives a good example of these comments. This is on page 218 under intoxicated persons. Now, Oliver and Wendell, the same Oliver, not Oliver who had Alzheimer's. This is a different Oliver, but same names. Oliver and Wendell were at a bar drinking heavily. Wendell writes on a cocktail napkin, because you have bought me so many drinks and been so nice, I will sell you 100 widgets for only 5 cents per widget. Now, we discussed last example with the same Oliver and Wendell that it was $1 per widget, but now we're selling them because you're so nice and we're drinking heavily. And one party says, because you've been so nice, I'm going to sell it to you for 5 cents. Obviously, a very low discount from the dollar, which is, so basically this is way below market value. Now the next day, Wendell, he sobers up, he wakes up, and he realizes what he did. Now Wendell may avoid the contract because he was so intoxicated. Now a reasonable person would have known that he was so intoxicated that he was unable to act in a reasonable manner, and because Oliver had reason to know of Wendell's condition because he was there, he was the one buying him drinks. He saw him stumbling, not able to talk, slurring his words. He said, I can't drive, I need a designated driver. A lot of things like that. Now, a reasonable person would have known that this individual does not understand what he's signing. So therefore, it would be, he would not have capacity to sign, therefore not a valid contract. Now, on the other hand, this is just a different example. If Oliver and Wendell were out drinking together, but neither was obviously impaired or drunk, so this is different. They're not so drunk, but they've been drinking. Their intoxication would likely, so they're still drunk because they're intoxicated, but it will likely have no effect on the validity of the contract. So it will probably most likely still be a valid contract. This is more of the, because of the reason, the first example, the one who was drinking, Wendell was drinking, and Wendell was the one who wrote on a napkin. Oliver had reason to know. Oliver was there. Oliver saw Wendell drinking. Oliver was the one who bought him the drinks. Oliver was the one that saw Wendell not be able to walk, had to be carried out of the bar, all of those things. So he had reason to know. So this is more about just a public policy about taking advantage of someone. Just if you're buying them drinks and you know, a reasonable person would know that that person was drunk way beyond their capacity, then, no pun intended, but then they would lack the capacity. However, in the second example, if both of those guys were drinking together at the bar, they were not so obviously drunk, they were just drinking and intoxicated. The court might hold and say, you both were drinking, you both still had capacity and enough common sense to know what you're doing. Then a judge might say that contract is valid and an enforceable contract on both of them. So this is just an example on 218, intoxicated person. Two different examples that I wanted you to know how almost similar circumstances can have different outcomes. And the majority, I think, or here the main factor is that one person had maybe leverage, had reason to know that the other person was severely intoxicated. Therefore, one person can be seen as severely taking advantage of another person. I think that was the difference here and why the judge will rule in different ways. Let's go on to the next slide and keep talking about this. Now, jumping on to slide number 13. Here we're going to discuss the difference between the bright line rules versus the flexible standards. Now, the bright line rules, those are going to be clear cut and easy to apply, such as, for example, determining whether a person had reached the age of majority. If they haven't reached the age of majority, which is adulthood 18, then that's easy to say, you know what, it was not able, that has not been reached. It's a clear cut. It's either you're a minor or you're an adult, or for example, you say either you're an adult or you're not. It's easy to apply that standard. However, there's also the flexible standards. They're more like general guides or guidelines. They provide a greater range for choice or discretion. For example, determining whether an adult is lucid or intoxicated is a judgment call based on a wide variety of factors, right? So that's not necessarily the bright lines rule, or it's not clear cut. If someone says, it's the individual who signed the contract is 12 years old, well, that's easy. He's a minor. It's a voidable contract. There's no question about it. He's a minor. It's just a question of fact. It's just a number. Now, however, for a flexible standard, if someone, perhaps maybe I was in my example where it was Oliver and Wendell, they were at the bar. I believe Oliver was the one who was heavily drinking, and the other individual kept serving them drinks, buying them drinks, saw him fall over, things like that. I mean, although one can argue, okay, well, the Wendell, the person, or the more sober person should have known that Oliver was heavily intoxicated, that's still going to be a question of fact. That's not a guarantee. There's still going to be some discretion. I mean, if Wendell was intoxicated, but he did certain things that someone can argue, say, well, he wasn't really intoxicated because he did A, B, C, and D, and that's necessarily pretty difficult for an intoxicated person to do, then at that point, it's going to be more of a discretion based, not necessarily clear cut as a bright line rule would be. Okay, but let's go to the next line. Let's give some examples between the bright line and the flexible standard. Now here on slide number 14, just some examples. We kind of just touched on it briefly on the previous slide, but I want to give this example with this illustration of example of bright line rules versus the flexible standards. Now a bright line rule, as we said, is clear cut. If one signed a contract and they were 10 years old, that it's pretty clear cut that they don't have capacity. They're a minor. Same thing for a speed limit. The speed limit is 60 and they clock you doing 80 miles an hour. That's clearly you've been speeding. There's no really discretion on that. It's just a number. You were going 80, they were going 60. You don't really have discretion or a kind of a wiggle room to get out of it, or at least some sort of reasonable argument to get out of it. The flexible standards, for example, they're going to be more discretion based. They're going to, for example, the definition is someone is mentally competent. That's going to depend on several factors. That's not going to be as easy as determining that individual was a minor. It's going to, a lot of factors are going to come into play if they were competent. I know they gave the example of intoxication. Perhaps maybe an elderly person can argue they're not able to understand. If someone, an elderly person is, for instance, 95 years old, they may fall under the defense that they lack capacity to understand the contract, the terms of the contract, and the consequences. They can have that argument. However, they are other 95-year-olds who understand everything, who are very competent and able to write books and read and write their own contracts. I know of attorneys who are in their 90s still working, so they're still very competent. But one 95-year-old can perhaps, or 90-year-old can have the defense to say, I'm 90 years old. I didn't understand the terms. I didn't understand the consequences. However, another 90-year-old can say, yeah, I'm still a lawyer and I'm still practicing. I'm still working. So of course I understand. So that's where it's not a bright line rule. That's when it's a flexible standard, especially to meet the mental capacity. That's going to be based on facts presented to the jury, and for the jury to decide if he had mental capacity to sign that contract. Let's go to the next slide. Here we are, guys. We're almost there. Just a couple more slides. So this video is going to be a short video as compared to the other weeks. But now going on to the fourth element. Again, just a quick review. We talked about the first element. There must be an agreement, which is encompassed by an offer and acceptance. There must be consideration. Both parties have to gain something of value, and they must get a detriment. They must have a burden. And then the third one, they must have capacity to sign. They must be able to understand the contract. Now, the fourth one here we're going into is legality. Now, for a contract to be enforceable, it must also meet the standard of legality. The subject matter and the performance of the contract, it must be for a legal reason. Now, for just two things. The statute, now some contracts are illegal because their items violate statute. They violate a law. For example, illegal gambling contracts, or perhaps maybe minimum wage laws. Perhaps an example is if I'm an employer and the minimum wage that which is set by law is $7.25. Therefore, I cannot have a contract with an employee and say, you know what, minimum wage, I can't make it. That I want to hire you, but I can't pay you minimum wage. I can offer you $5 an hour, and then at that point, then that we sign an employment agreement. It is to pay you $5 an hour, which is under minimum wage, which is the law. So basically, I'm disregarding the law and paying what I think, paying under it. That contract is not legal, so it doesn't meet the legality standard, because there is a statute already in place that holds that standard and makes it illegal. Now, this is an easy example where we can show that the contract is unenforceable because the fourth element of legality wasn't met. The minimum wage is $7.25. There's an employment agreement for $5. So it's an illegal contract. Besides being an illegal contract, not only if the Texas Workforce Commission finds out that you are paying your employees $5 an hour, they'll probably come back and the employer will be in bigger problems and have to pay minimum wage for all those hours that they worked at $5, and most likely receive penalties and things like that. So it's not just for the sake of having an illegal contract, but for the sake of your business and your future business. You don't want to pay people under minimum wage. And now, second one is public policy. Some contracts are illegal because they contain terms that violate a public policy objective, such as contracts in the restraint of trade. Or one example of this, it's necessarily you're not violating the law, but it is against public policy. If you make a contract with a public official, basically a bribery contract, hey, I'll donate $10,000 to your campaign. However, when a certain vote comes to the House or to vote on, you need to vote a certain way, because that affects my business. So I'll give you $10,000 if you vote a certain way, or I'll give you $10,000 if, when contracts come up for the government, you make sure I land the contract, or my company lands the deal. Then those contracts, they're necessary. There's no law that's specifically gonna touch on every single thing that is happening in that situation, but it does go against public policy. It harms the public for those type of contracts to be enforced. Therefore, that law isn't as clear as the minimum wage one, but this does go against public policy. Therefore, it is not a legal contract. It cannot be enforceable. So that's a legality standard. Let's go on to the next slide and chat a little bit more. Now, here we are, guys. Slide number 17. This is the last slide, at least this last subject matter slide in this presentation. Now, exceptions to the non-enforcement rule. Now, generally, courts, they're not going to enforce illegal bargains. They're not going to enforce legal contracts that we discussed before. For example, a bribe contract, or a contract that I'll pay you a certain amount of money if you import or smuggle in illegal Cuban cigars for me. The courts, that's an illegal contract. They're not going to enforce or protect the parties. They're going to leave the parties where they find them. That the courts say, we're not here to protect illegal contractual obligations. We have nothing to do, and then they're not going to touch that contract. However, there is certain exceptions to an illegal contract. Now, I'll read this definition and give you an example. I think that'll clear this up. But when a party to the contract, now when an individual in the contract is a member of the class of persons whose protection the contract was made illegal, he may enforce it to obtain restitution. He may enforce it to gain the benefit. For example, if an insurance company writes an insurance policy to an insured, but they use the wrong form, or the not approved form, the insurance company may say this form wasn't approved by the state. We used the wrong form. Therefore, it is an unenforceable and an invalid contract. It is a non-enforceable contract. However, that contract, it is for the protection of the insured. Therefore, the insurance company, if something happens and the insurance files a claim, the insurance company can say, no, you know what, after reviewing the contract, and when it's a legal contract, because what was used was an illegal form, or perhaps maybe changes were made that were illegal, and therefore it is a illegal contract. The court may still enforce that illegal contract to protect the member who the contract was made to protect in the first place. So that's the insurance. That's a good example of this exception rule to an illegal contract. Well, that's all I have for the subject matter. Let's just talk real quick and jump on the next slide about the next chapter we're going to view and closing points. Thank you. Well, this is the ending slide, slide 17. Thanks a lot, guys, for joining me for this presentation. This presentation was week 5, chapter 9, contracts. Continuing on contracts. Last week we discussed chapter 8. We discussed 2 weeks ago chapter 8. Then this week we discussed chapter 9. And then next week we're going to still stay on contracts, but we're going to discuss chapter 10, the enforceability of contracts. Again, for next week, the chapter 10, I encourage you to read chapter 10 before watching the video, and then look at the video for next week. But I'll see you guys next week discussing chapter 10, enforceability. Thanks, guys. See you next week.